welcome back to the deep dive.
Hi.
Okay, if you need a crash course on how one of the most contentious constitutional rights in America has basically been completely transformed in the last 15 years or so, you are definitely in the right place.
It's true.
For almost all of U.S. history, the Second Amendment was, well, largely ignored by the Supreme Court. But today, its interpretation is driving court challenges across literally every state and city in the nation.
It's a really remarkable shift, and it all kicks off with those 26 words. The test itself reads, "A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms, shall not be infringed."
Right.
And for decades, the legal community was totally hung up on that first part, the militia clause.
Was the right tied only to being in a state militia? Like a collective right?
Exactly. Or did it protect individuals, separate from any military service? An individual right. That was the big debate.
And the court hasn't just settled that debate, but in doing so, it's fundamentally changed how every single gun regulation in the country gets looked at. So, our mission today, unpack three huge Supreme Court cases: Heller, McDonald, and Bruen.
The big three.
Yeah, the big three. And crucially, explain this brand new, sometimes pretty controversial standard courts now have to use to test every local or state law. It's basically like a legal time machine they've built. Okay, so let's set the scene. Before 2008, what was the general understanding?
Well, among many federal circuit courts anyway, the common view was that this was mostly a collective right, tied to military service, like you said.
And how did earlier cases play into that?
If you look way back, 19th century cases like Cruikshank and Presser, they limited the Second Amendment only to what the federal government did, not states or cities.
Okay.
But the really significant 20th century case was United States v. Miller. That was 1939. And that ruling seemed to, well, reinforce the idea that the right was only there to make sure the militia could function effectively.
Why is that perspective so important? Thinking about modern gun control history.
Because if it's only a collective right, then states and cities could pass almost any gun control law they wanted without a serious constitutional fight,
Right, the Second Amendment wouldn't really be a barrier.
Exactly. If you were, say, a city council in the 80s or 90s trying to ban certain weapons, the Second Amendment probably wasn't seen as a major hurdle. That whole environment just changed dramatically in 2008. With District of Columbia v. Heller.
Heller. Okay, the first really deep look at the Second Amendment in almost 70 years. And it struck down D.C.'s handgun ban, which was pretty comprehensive.
It was seismic, a huge shift. The core ruling, and it was close, 5-4, was that the Second Amendment protects an individual right.
Individual, not collective.
Right, an individual right to have firearms for historically lawful purposes, and specifically self-defense in the home.
How did they get that from the text after all that focus on the militia clause?
They looked hard at the phrase, the right of the people. And they noted that elsewhere in the Bill of Rights, First Amendment, Fourth Amendment, that phrase always means an individual right, not a collective one.
Ah, okay. Consistency.
Yeah. So that sort of resolved the textual puzzle, establishing the individual right to possess and carry weapons, for self-defense mainly.
But hang on, if they established this individual right, they didn't just say anything goes right. They were quick to add some limits. What are those Heller exceptions we still hear about?
That's absolutely vital context. The Heller court really stressed that the right is not unlimited. They explicitly said their decision did not cast doubt on certain long-standing prohibitions that were considered presumptively lawful.
Like what?
Things like banning firearms for convicted felons and people with specific mental health issues. Also, bans on carrying weapons in sensitive places, think schools, government buildings, and laws setting conditions on commercial gun sales.
So Heller sets up the right, but immediately carves out space for regulations that have some historical basis.
Exactly. Rooted in historical tradition, that was the key phrase.
Okay, so Heller establishes the individual right in 2008. Big step. But critically, it only applied to Washington, D.C., because that's federal territory.
Right.
So if you lived in, say, Chicago or New York or somewhere else, your city could potentially still ban handguns entirely. Right. That leads us to the 2010 case.
Precisely. That brings us to McDonald v. City of Chicago. The big question for the court then was, does this individual right established in D.C. also apply against state and local governments?
And this involves that legal idea of incorporation, using the 14th Amendment.
That's it. The court looked at the 14th Amendment's due process clause. It basically says states can't infringe on fundamental liberties. So they asked, Is the right to keep and bear arms for self-defense one of those fundamental liberties?
And their answer.
Yes. They decided it was deeply rooted in this nation's history and tradition. So the outcome was that the individual right from Heller became a fundamental right. And that means it's enforceable against state and local governments all across the country.
Wow. So Heller was like a shield, but only for federal actions. McDonald basically extended that shield nationwide, covering every city ordinance, every state law. That must have really ramped things up.
Oh, absolutely. It dramatically escalated the potential for litigation. The whole national conversation shifted instantly because suddenly every state and local gun rule was potentially vulnerable to a Second Amendment challenge.
Now, this is where, for me anyway, it gets really interesting, especially for anyone trying to follow how courts actually deal with these challenges day to day. Post-Heller, post-McDonald, lower courts had a problem, right? How do you balance this new individual right against, real pressing modern public safety concerns?
That's exactly the dilemma they faced. And to solve it, many of them developed what became known as the two-step analysis.
Okay, 2 steps. What were they?
Step 1 was basically checking the text. Is the activity, like carrying a gun outside the home, even covered by the Second Amendment's historical meaning? If the answer was yes, they moved to Step 2.
And Step 2 was?
Step 2 applied a kind of modern constitutional review, usually something called intermediate scrutiny.
Intermediate scrutiny. What is that, in simple terms? And why do the courts seem to like using it here?
Intermediate scrutiny is essentially a balancing test. It lets a court uphold a law if the government can show the regulation is substantially related to an important government interest, like public safety.
So it lets them weigh things.
Exactly. Lower courts liked it because it gave them flexibility. They could potentially uphold regulations designed to deal with modern problems, think bans on high-capacity magazines or strict limits on concealed carry permits, even if those exact laws didn't exist back in 1791. It let them balance the right against current safety needs.
But their Supreme Court eventually put a hard stop to that whole balancing act. Which brings us to 2022. New York State Rifle and Pistol Association v. Bruen.
Bruen, yes, a landmark case. It dealt with a New York law that required people applying for a concealed carry license to show proper cause, meaning you had to prove you had a special need for self-protection, something different from just the general public's concern for safety. You needed a specific reason.
Okay.
The court, in a 6-3 decision, struck that down. They said, first off, that carrying arms in public for self-defense is covered by the Second Amendment. But the really critical part of the ruling, they completely rejected that 2-step framework the lower courts had been using.
Just threw it out. Why? Why reject intermediate scrutiny? Wasn't it, a reasonable way to weigh public safety concerns?
Well, the majority argued that using that kind of means-end balancing test, like intermediate scrutiny, just wasn't consistent with Heller's focus on history.
How so?
They felt it gave judges too much kind of subjective power to decide if a modern gun law was important enough or related enough. They basically said, look, if the government wants to regulate a constitutional right like this, it can't just argue the law is a good idea today. It has to prove the law is consistent with the historical tradition of firearm regulation.
Wow. Okay, so if the government can't use public safety stats or modern policy goals anymore, what is the new standard? This is the Bruen test, right? The time machine test you mentioned.
That's a pretty good way to think about it, yeah. The standard is now rooted solely in Texan history. That's it. It still has 2 steps, but they're very different.
Okay, break it down for us.
Step 1. Does the plain text of the Second Amendment cover the individual's conduct? The Bruen court said bear arms naturally includes carrying them in public outside the home. So if the text covers it, the conduct is now presumptively protected.
Presumptively, okay.
Then what?
Then step 2. The burden shifts entirely to the government. They have to justify their regulation. And the only way they can do that is by demonstrating that the law is consistent with this nation's historical tradition of firearm regulation. So let me get this straight. If you live in a city and your council wants to pass a new gun restriction, the court is basically saying the government can only enforce that new law if it's similar to restrictions that actually existed back in, 1791 when the Bill of Rights was ratified, or maybe 1868 when the 14th Amendment came along?
That's essentially it. It requires what the court calls reasoning by analogy. They did acknowledge that today's challenges, things like semi-automatic rifles or concealed carry in crowded cities, are obviously different from 1791.
Understatement.
Right. So courts have to look for historical laws that are relevantly similar, and they judge similarity based on 2 things. How the old law worked, like was it a ban, a tax, a storage rule, and why it existed, what was its purpose, Disarming dangerous people, raising money, something else.
And the New York law in Bruen failed that test.
It did. The majority said they couldn't find any historical tradition in America that made people prove a special, individualized need before they could carry a gun in public for self-defense.
That sounds incredibly difficult for the government. It's like asking a court to find a historical rule for regulating smartphones based on rules for, I don't know, telegraphs. How similar does a modern law need to be to some old law? Did Bruen mean it had to be a historical twin?
That exact question caused immediate confusion, almost chaos, in the lower courts right after Bruen. Some courts read it very, very strictly, demanding almost identical historical laws.
Which probably don't exist for many modern issues.
Often, no. That uncertainty, though, was finally addressed just this year, in June 2024, with United States v. Rahimi. This was the first major Supreme Court case applying the Bruen history and text test.
Rahimi. Okay, what was the specific law being challenged there?
It was a federal law. It prohibits people subject to domestic violence, restraining orders from having firearms, and crucially, this only applies when a court has already specifically found that the person poses a credible threat of physical violence to someone else, like an intimate partner or child.
And the lower court, the Fifth Circuit, initially struck that law down using Bruen.
Yes, they did. They basically said the government hadn't found a perfect historical match from the founding era for disarming someone under a domestic violence order.
So what did the Supreme Court say? How strict does the historical comparison have to be?
This was the key clarification in Rahimi. The court said Bruen requires a relevantly similar historical analog, not a dead ringer or a historical twin. They specifically told lower courts to seek harmony, not to manufacture conflict between modern laws and historical tradition.
So easing the standard a bit, focusing more on the underlying principle.
You could say that. They emphasize that the principle behind the historical law is what matters most, not necessarily the exact way it worked. It's about finding laws that address a similar societal problem in this case, disarming dangerous individuals.
Okay, so based on that clarified standard, relevantly similar, did the domestic violence restraining order law survive?
Yes, it did. The Supreme Court upheld the federal law. They looked at various historical laws, things like old surety laws, where people who threatened others might have to post a bond or risk losing their weapons if they didn't keep the peace.
Ah, so an indirect way of disarming someone seen as dangerous.
Exactly. They also looked at old laws regulating going armed in a way that could terrorize people. The court found that these historical examples showed a clear tradition of disarming individuals who were deemed dangerous to others, particularly those posing a risk of physical violence. So Rahimi showed the Bruen test is demanding, yes, but not so rigid that it automatically invalidates laws aimed at historically recognized dangers. So if we just quickly recap these last, 15, 16 years, it's been a whirlwind. The Second Amendment right has gone through 3 massive shifts. First, it's now definitively an individual right.
Sure.
Second, it applies to all 50 states and cities, thanks to the 14th Amendment and McDonald.
Yes.
And third, all gun regulations now have to pass this demanding history and text test established in Bruen, looking back to founding era tradition.
So why should this matter to you, listening right now? Well, that Bruen standard means every single challenge to a new gun regulation, whether it's passed by your local town council or your state legislature, is now decided not based on today's crime statistics or public safety argument, but through this often long, complicated, and very specialized process of digging through historical records. Lawyers and judges are now essentially becoming historians, trying to apply 18th century legal traditions to solve 21st century problems.
And that raises the final, really critical question that courts all over the country are wrestling with right now. The court in Rahimi upheld that domestic violence law by finding relevantly similar historical laws. If the core right is about armed self-defense, how far can that tradition of firearm regulation be stretched? Can it address dangers like, say, the technology of modern weapons capable of mass casualties, or the specific threat of mass shootings, things the founders literally could not have conceived of?
That tension, right, between a fixed historical tradition and a rapidly changing modern world.
Exactly. That's the defining legal battleground for the Second Amendment in this decade.
A fascinating and ongoing test of history versus modernity. Thank you so much for guiding us through this incredibly important deep dive.
My pleasure. It's certainly a lot to track.